Welcome to An Ounce of Prevention, the podcast. At RR&A Associates, we believe that an ounce of prevention is worth a pound of cure. Our daily commitment lies in informing our clients about legal risks without hindering their business objectives. As we like to say, we're in the business of building companies and helping executives sleep at night. So stay tuned. Maybe you'll learn something that'll help your business grow and thrive.
Welcome to An Ounce of Prevention, the podcast, where we believe an ounce of prevention is worth a pound of cure. In every episode, we will dive into the steps you can take today to protect and strengthen your business for tomorrow. I'm your host, Rachel Reese. Today, I'm going to talk you through the various types of agreements that you can use to paper up your transaction and give you some insights for how to determine which one is the best for your situation. After, be sure to stick around to hear our much-loved case law update, where I'll be examining the Texas Supreme Court's decision in Cromwell versus Anadarko, a case that clarifies how a passive habendum clause can affect lease rights and what this decision means for lessees going forward. Attention, all you dealmakers in the Houston area. Get ready for the inaugural Dealmakers Haunted Hall Gala on October 23rd at Meow Wolf Radio Tav. It's going to be a night of networking, giving back, and some spooky thrills. The Dealmakers Haunted Hall Gala is your chance to meet with industry leaders while making a real impact on the communities we serve. This event isn't just about fun, it's about giving back to those in need. We're looking for sponsors to help make this event a success. With sponsorship levels ranging from $2,000 to $5,000, every contribution goes towards supporting local communities and making a difference where it matters most. The more sponsors, the greater the impact. We need your help to make this unforgettable. Visit www.rreslaw.com for information about events, tickets, and sponsorships. Email rlamphere@rreslaw.com to sponsor and be a part of something bigger than just an event. Let's make Halloween one to remember. Dealmakers Haunted Hall Gala, where the networking meets charity in the spookiest way possible. Now, let's talk about transaction agreements. In the energy space, when buying and selling assets and companies, there are a variety of different types of agreements that you can use to get the job done. Your most basic documents are your conveyancing documents, like an assignment, a bill of sale, or a deed. These are the documents that actually convey any real property assets and get recorded in the county records. You use a deed when you are conveying land, an assignment when you are assigning rights or contracts, and a bill of sale when you are conveying personal property. Most oil and gas deals will convey leases, contracts, and equipment, and will use an assignment and bill of sale. And sometimes that's all you need. If you're doing a very straightforward deal involving a small amount of money, and you're okay with the terms of that deal being in public record, you can get by with just an assignment and bill of sale or a deed, or some combination of them. But more often than not, even with a smaller sized deal, the parties don't want all the terms of their deal in the public record. When that happens, we usually recommend a letter agreement to accompany the conveyancing documents that details the rest of the agreement that the parties have. Think indemnities, details of when and how payment will be made, adjustments, etc. Letter agreements are commonly used when you're signing and closing at the same time and should be no more than a few pages long. If your deal is bigger or more complex, or if you plan to sign, have an interim period, and then close, then you're going to need a purchase and sale agreement, or a PSA. A PSA can range from about 10 pages to over 100 pages, depending on the deal, and will address things like diligence, defects, adjustments to the purchase price, representations and warranties, all the stuff going on between the parties. It'll often have exhibits and schedules and make reference to other ancillary documents involved in the transaction. What I've talked about so far has been focused on asset sales, but what about company sales? When you're buying a company as opposed to an asset, you need a completely different type of agreement. People will sometimes get this confused and try to make a PSA work for this type of transaction, but it just doesn't work. And this is because you're buying a completely different asset class. While you'll be getting all of the assets of the company, what you're actually buying is the equity in the company itself. You do this either through a stock purchase agreement or a membership interest purchase agreement, depending on the type of company that you're buying. Because you're buying equity, you're now buying not just the rights and liabilities involved with the assets, but so much more than that.
You have to address in your agreement the rights and liabilities at the company level. So in addition to thinking about title issues, environmental issues, you're now thinking about employee issues, intellectual property, accounting, bonding, all of it. And the SPA or the MIPA are set up to address those issues. So I'll end with this. Whatever type of deal you're trying to do, it's important that you use the right agreement. Make sure you're talking to legal counsel, even if it isn't us, to make sure that the agreement you're using is the right agreement, and more importantly, has the right types of protections for you. I hope you learned something today. As always, feel free to contact us if you have any questions about which transaction agreement you should use, or you'd like to be a guest on the show. Email us at podcast@rreeselaw.com. And now it's time for another case law update. Today, we're unpacking a recent ruling from the Texas Supreme Court called Cromwell versus Anadarko E&P Onshore LLC. Let's break it down. This all started when David Cromwell signed 2 oil and gas leases in 2009 on land in Loving County, Texas, as lessee. Cromwell wasn't the operator. Anadarko was the operator, who already had producing wells on the property. Cromwell didn't drill or operate any wells himself, but he did receive revenue from Anadarko and covered his portion of operating costs, just like any non-operating working interest owner would under a JOA. But Cromwell didn't have a JOA with Anadarko. Now, the leases both included a habendum clause, the part that states how long the lease lasts. These clauses were written in the passive voice, saying that the lease would continue as long as oil or gas are produced from said land. Notice it doesn't say by whom, and that's exactly what the issue is in this case. Anadarko claimed that Cromwell's leases had expired and secured top leases from the mineral owners under Cromwell's leases. Their argument, since Cromwell hadn't personally caused production during or after the primary term of the leases, his rights had ended. This is a practice known in the industry, funnily enough, as an Anadarko washout. Cromwell filed suit to assert that his leases were still valid. The trial court didn't agree, and neither did the Court of Appeals. Both relied on earlier precedent that leaned heavily on implied obligations, specifically that a lessee must do something active, like drilling or signing a joint operating agreement, to keep their lease alive beyond the primary term. But the Texas Supreme Court disagreed. The court took a close look at the lease language and emphasized a key point. The leases didn't say production had to come from Cromwell himself. The habendum clauses simply said the lease would continue so long as oil or gas was being produced from the land. And since everyone agreed production on the land had continued, the court held that Cromwell's leases were still valid. In reaching its decision, the court reinforced a core principle of Texas contract law. Judges can't insert new terms into a deal that the parties didn't agree to. If the lease doesn't clearly require the lessee to drill or operate, the court isn't going to imply that obligation just because it might seem logical or expected. The court also noted that Cromwell had been treated like a working interest owner for nearly a decade. He was billed for expenses, he got paid his share of production by Anadarko, and he even approved expenditures. None of that matched the idea that his lease had quietly expired years earlier. Importantly, the court disapproved of earlier decisions by other courts, including Cimarex versus Anadarko and Madison versus Trotty, that had interpreted similar clauses to require personal action by the lessee. Those cases, the court said, went too far in reading implied duties into passive lease language. So what does this mean moving forward? Well, this is a big change in the law for non-operated working interest owners. Before this case, an operator could effectively wash out a non-operator's interest by refusing to circulate a JOA, and then claim that the non-operator had lost its interest by failing to produce from the land themselves. So operators and non-ops alike with assets in Texas should take a look at the leases covering their acreage and see if those habendum clauses contain active or passive language. It may just change your strategy going forward. That's it for this case law update. I'd like to thank Kanika Draxtrom, a law clerk in our Houston office, for her help on this update.
The information and material in this episode is general information about our practice and firm and is for educational and informational purposes only. This information does not offer specific legal advice, and the use of this information does not create an attorney-client relationship with RR&A or any of its attorneys. The information in this episode, or any episode of An Ounce of Prevention, should not be considered legal advice, and persons should not act upon this information without first engaging professional legal counsel.
Thank you for listening to An Ounce of Prevention, presented by R. Reese & Associates. If you found this episode informative, subscribe to, rate, and review our podcast on Spotify, Apple Podcasts, YouTube, or wherever
wherever you listen to stay up to date with future episodes, case law updates, and breaking news. If you have any questions or are interested in learning what RR&A's outsourced legal department can do for your company, reach out to us at podcast@rreslaw.com. That's podcast@RR&EESELAW.com. Follow us on LinkedIn or call 832-831-2289.